Hello viewers, I'm Advocate Kiara from Lexis and Company. Today we're going to talk about Order 6 Rule 17 under Code of Civil Procedure 1908. So, the provisions regarding pleadings are found under Order 6 of the Civil Procedure Code 1908. A pleading is the written form of a statement that is drawn up by both parties to a suit. The statements in writing include the contention and other details that the opponent needs to know to prepare her case for the trial. Statements given by the plaintiff are called a claim, and the same given by the defendant is called a written statement. Now, importance of pleading and its relevance to Order 6, Rule 17, CPC. The concept of amending pleadings can be easily understood if we know the purpose of a pleading. Pleading not only defines the issue between the parties but also helps in determining which of the parties has the burden of proof. One can say that it plays an important role throughout the whole process of litigation, as it also helps in determining the range of admissible evidence that the party should adduce at trial. The sole purpose of it to make each party fully aware of the issue that will be argued so that each party can present appropriate evidence for them. Now, talking about the Rule 17 of Order 6 is applicable in a situation where it becomes necessary for a party to make some changes to the pleading. This refers to the process of amending of a pleading, which is explained in this particular section. So, amendment of pleadings, Order 6, Rule 17, the court decides a case on the basis of its merits, that is, on the basis of facts, proof and evidence. Suppose the merits of the case are not completely mentioned in the pleading of a certain case, then the decision made by the court cannot be considered complete justice, as the merits were not completely mentioned. It may also happen that the merits that were not mentioned held an important aspect regarding the case. Keeping this in mind, the court are empowered to grant permission to amend the pleadings. Hence, the concept of amending pleading steps in Order 6, Rule 17 of the CPC grants permission to the parties to the case to amend their pleadings at any stage of the proceeding. The provision under this rule says that after the trial has commenced, an application for amendment shall not be allowed. However, it might be allowed if the court thinks that in spite of due diligence, it was not possible for the party to raise the matter before the trial commenced. This statement can be explained using the following examples. A person by the name A files a lawsuit against B. The suit was filed in a hurry because it had some limitations. So, after filing the suit, A realizes that there are some important facts, proofs or documents that he could have added to his pleadings earlier but not due to so as they were not in his knowledge at that time. In this case, the court might give a permission to amend his pleading. It is the discretionary power of the court to grant permission or not. Such application is not governed by the law of limitation. That means there is no limitation available against this provision, and an application to amend the pleading can be granted at any stage of the proceedings. I hope we are pretty much clear with Order 6, Rule 17 under CPC, amending of pleadings. If not so, then do let me know in the comment section regarding all your doubts and queries, and I will see you guys super soon in my next video with some other legal topic.